All right, hello and welcome to this evidence capsule, which is focusing on the law of corroboration. In this capsule, I'll be dealing with the legal concept of corroboration and how it is treated in the law of evidence, and that is not always easy. Corroboration can be a bit of a complex topic for students and lawyers alike, and that's partly because corroboration has been treated differently over time, and the law does not always reflect all of these changes, and as you'll see, the different ways in which the concept of corroboration is treated in different settings, and you really have to be careful of really which setting you are using this concept in because it's different everywhere. Now, this part of the capsule, this capsule is going to be one of three on this particular topic, and this capsule is designed to provide an overview of what the term corroboration is and how it gets used in different legal settings. In subsequent capsules, I'm going to look at each of these settings in more detail and show how the law has evolved, because as you'll see, corroboration really means different things depending whether you are in a civil trial, a criminal trial, and believe it or not, depending in which sort of criminal trial you are in. So this can be a bit complex, and we're going to need to address all of those scenarios. I remind you that this capsule is looking at an overview to describe to you how corroboration gets treated. In subsequent capsules, I will deal with each of these types of corroboration in more detail. So a very brief overview, to the extent I haven't provided it. What I'm going to be looking at, as I said, is each of the different ways in which corroboration arises and essentially what corroboration was historically as a concept. Then I'll talk more in detail about how corroboration is simply an evidentiary concept rather than a rule, but one you should understand. Next, I'll look at the small number of situations in which corroboration acts as a statutory condition. And finally, I'll look at the term corroboration in which it's most commonly used at common law, and really what corroboration refers to is something that I'll explain is called a Vetrovic warning after the name of the case in which this warning was first proposed. So you can see with all these aspects of corroboration how corroboration can come to be confused. So let me provide you with a very brief overview that explains what I'm going to be getting at and why corroboration has so many complicated aspects. So it's actually kind of helpful to blend in together the first and second part of this, an overview with what corroboration is as a concept of proof, because I think that'll help explain where we're going and why corroboration tends to be so complex as a legal concept. Corroboration as a concept of proof is very, very straightforward. So let's just assume you have a witness A, and this witness is testifying to an event, and they talk about what that event is, X, Y, Z. Doesn't really matter what it is, but let's assume that their evidence has testimony that is X, Y, Z. The basic burden of proof in both a civil and criminal proceeding essentially posits that, let's take a civil proceeding, that your goal is to show that your evidence is more likely to be true than the other person's evidence. And as a simple, straightforward concept, you can prove your entire case by using just one witness, right? If your witness is very compelling and they want to talk about an event, and if you think about it in the lowest courts in the country, in small claims court, that's the way most things are proved. You've probably seen it on TV, which is a bad example, but nonetheless, the idea that A comes up, tells their story, and the judge decides either to buy it or not buy it based on certain things. There's a lot of ways in which you can examine a person's credibility and reliability, but leaving aside more controversial aspects like the way they look, you can think about how plausible their story is, how well does it conform to the way in which people ordinarily act, things like that, and you can come away with a decision that favors this party based exclusively on the evidence of A. But let me just say that while that's true, you don't want to do that very often, and no party sets out to try and prove their case based on the legal concept that you are permitted to win on the evidence of one witness. The more common way to try and win your case is by tendering as much evidence as you can. And much of this evidence is tendered for one purpose: corroboration. The idea is that you try to corroborate aspects of the witness's testimony. So let's say, for example, X is, I went to the store and bought some groceries at 8 p.m. Well, great. So you tender corroborating evidence, and that is evidence either from the shopkeeper or perhaps a receipt from the store at that time. And this evidence is not proof in and of itself of your claim in the fact that it actually advances what happened at the store at that time, but what it is corroborating evidence. And the sole purpose of corroborating evidence is really to make a trier of fact more likely to accept that the version of evidence given by this person is true. And that's why in court cases you'll often see corroborating evidence about X, corroborating evidence about Y, and corroborating evidence about Z. And let's just say right from the outset that as far as this goes, this is not a legal concept. It's not like you're legally required to provide corroboration. It is just simply that corroboration is helpful to the way in which people evaluate decisions. So therefore, it's a concept. It's an idea that we should have evidence to support the way in which claims are made. And that is more or less what corroboration is as a concept of proof, and I don't need to speak more about it, except that it flows into the overview of where the confusion comes from as a matter of law. And I guess what I mean by that is, as long as we're talking about corroboration as a concept of proof, who cares? Except that the common law and statute law haven't always looked at it that way. They have made corroboration more than just you should have this evidence to corroborate your testimony. And they transformed it into you must have it. And, in the early days, a couple of hundred years ago, corroboration requirements were everywhere. They existed as a matter of statute and they existed as a matter of common law. A very famous one involved children. Unsworn evidence of children, so don't worry about what unsworn is, but essentially unsworn evidence of children that was by children of a young age had to be corroborated. And if you couldn't corroborate that evidence, the accused had to be acquitted, which led to a lot of acquittals in sex abuse cases, as you can imagine, because many of these things were not corroboratable. They took place in private. So the need for corroboration essentially changed the burden of proof, but not really a concern for us. What is a concern for us is how we deal with it. What happened was the common law and statute law began to put in very onerous requirements about what it means to corroborate evidence. And that does concern us. So I won't bore you with it because most of this precedent is long since gone. Right? It's important for understanding the genesis of today's modern corroboration requirements, but we don't need to look at it any further except to know that in the old days, these corroboration requirements were onerous and they were very particular. I mean, you know the way the common law works. It starts out as you must do X, and then before you know it, it's you must do X, Y, Z, Q in a particular way, distinguishing this case from that case. And what you had was a very messy situation in which a lot of corroboration requirements existed, number one. So that was problem number one. A lot of them existed. The other problem was that they were very complex. And if I can tell you, you go back and look at the cases, especially in criminal law in the 60s and 70s, it was absolutely ridiculous. Cases were getting overturned on appeal all the time because essentially, if you have a corroboration requirement, it has to be explained properly to the jury, and it was exceptionally complex. It had to connect, the corroboration requirement had to connect to particular things. They had to implicate the accused. They couldn't just make it more likely that what the witness was saying was true, which is the modern way we look about corroboration as a concept of proof, what I told you just a few minutes ago. That wasn't good enough. Corroboration became a very legally complex exercise that connected a person to proof. All of that changed. Essentially, it changed in two ways. One was statutory reform. So what happened was a lot of the statutory requirements to corroboration got abolished. So for example, believe it or not, there was a corroboration requirement for women in sexual cases that was set up at common law. There was a corroboration requirement for kids in sex cases, and that was a requirement that was abolished. Corroboration requirements were abolished all over the place. But some of them still exist, which is why I'm about to talk to you in a few minutes about corroboration as a statutory condition, because where those corroboration requirements exist, some of the existing law or the way we approach corroboration remains important. But luckily, for our purposes, when we talk about corroboration as a statutory condition, very few requirements still exist. So that's very helpful for all of you who are worried about the technicalities I was just talking about. In criminal law, the only relevant corroboration requirement left, there's only one: perjury. Perjury still requires corroboration about the nature of the falsity in question. So if you have a perjury case, you need to know about corroboration. There are two others, feigning a false marriage and treason, but those are never charged, so we don't have to worry about those in criminal law. Every other statutory corroboration requirement has been abolished. And as I will show you, there are still a small number of corroboration requirements in civil cases, and I would argue one of them is very important, which involves corroboration in estates cases. And I'll talk about that in just a moment when I get to corroboration as a statutory construct. But just to keep going where I was going, statutory reform was only the first significant change. Probably much more important was common law reform, and two cases drove this. One was called Workington, and the other was called Vetrovic, which I'll come to. So Workington has been forgotten. I think it's the more important case because it essentially says we're not going to keep going the way we're going, but let's be honest, Vetrovic is the case that everybody remembers today. And I'm going to sum up Vetrovic in very simple fashion. Most corroboration requirements were common law requirements, so simply reforming the statutes and getting rid of the ones that were listed in statute doesn't change where we're going. You need to change the common law as well. And Vetrovic did two important things. One is it reduced the need for corroboration altogether. But it recognized, and I'll talk about this in a bit, that there was still some logic to some aspects of the corroborative requirements. Essentially, make this as simple as I can. There are situations in which witnesses give evidence, and we have to be worried about the fact that their evidence is in no way corroborated, because even though the Crown has the burden of proof beyond a reasonable doubt, there is a worry that people will be compelled by things they don't understand. So jurors will look at this evidence and think, wow, it's really good. That person's very believable. For that reason, there are still some concerns about corroboration. So even though the court reduced the need for corroboration, that was the first part, they still recognize that there should be some focus on the concept. But the way in which they did that was what changed. No longer a formal requirement that you can't convict in the absence of corroborative evidence, they created what came to be called as the Vetrovic warning. In some cases, there will be a need for a clear, sharp warning that a jury should not convict in the absence of corroborative evidence. And that is why when we talk about Vetrovic warnings, we're actually talking about what is referred to as corroboration as a common law concept. Essentially, when everybody talks about corroboration in most cases, because the statutory conditions are so few and far between, unless you're running an estates case, you're not dealing with statutory corroboration. Most times when you hear a judge or a lawyer talk about corroboration, they're actually talking about whether or not you need to give a Vetrovic warning. Okay? So that is how corroboration has evolved as a common law concept. And now I'm going to talk very briefly about the two remaining types of corroboration, although I will supplement these with later capsules. So the first of these two situations is corroboration as a statutory condition, and this is the one that I suggested was important. So in an action by or against the heirs, next of kin, executors, etc., an opposite or interested party shall not obtain a verdict unless the evidence is corroborated by other material evidence. And this is a pretty important corroborative requirement, and I love the quote, a famous quote from the Ontario Court of Appeal in a case called Burns Estate versus Mellon, says, "We need corroboration in these circumstances. It addresses an obvious disadvantage faced by the dead. They cannot tell their side of the story or respond to the living's version of events." And that's really important. I think that's why this corroboration condition continues to exist. So you have A come forward and says, well, B owed me $10,000. Okay, and we talked about it, and we had this long discussion, blah, blah, blah. And B is now dead. Got it? So A wants the money. A says, well, he owes me $10,000 or whatever. This corroboration requirement is designed to essentially put an evidentiary hurdle in the face of people coming forward and claiming all sorts of money from the dead. And it works the opposite way as well. If the dead person lends A $10,000 and it was a loan, but it's never clearly documented, well, the presumption that it's a loan rather than a gift, which I won't get into property law, is going to apply. And if A wants it to be a gift rather than a loan, A is going to need corroborating evidence. And that's really important. It's essentially a statutory condition. And to put it clearly, if they can't meet the statutory condition, then they can't win the case. It's just that simple. This has nothing to do with Vetrovic warnings. This has nothing to do with dangerous witnesses. Corroboration as a statutory condition is designed to rectify some sort of shortcoming that is inherent to the type of action in question. And that's why it's important. So you cannot ignore corroboration where it is a statutory condition. You need to deal with it and understand whether the evidence is actually corroborated by some other material evidence. And in a subsequent capsule, I will explain to you the way in which that's done. But for now, I want you to understand simply how this is different from any other type of corroboration. And finally, let me talk to you about corroboration at common law, which is based, as I suggested earlier, on the proposition that even where you have one problematic witness, like an eyewitness in this particular case, you can convict on the basis of that witness's evidence. Well, let's just say that the courts have recognized over time that in key cases, in cases where key evidence comes from a problematic witness, it's a good idea for juries to learn about the wisdom of judges' common experience. And the idea essentially is that juries don't understand that ID evidence can be wrong, no matter how sincerely held it is. And juries don't necessarily understand that where a jailhouse informant obtains a confession from somebody who is locked up beside them, there are many reasons to be skeptical of that sort of evidence. And as such, even though corroboration as a formal concept in the sense of the statutory condition I just showed you has been eliminated, the common law Vetrovic warning is still important. And what it means when we look at, the idea of the common law Vetrovic warning, there are certain cases in which you have to give a warning. And the question in any individual case then becomes, well, does a Vetrovic warning have to be given? And what does a Vetrovic warning have to include? Those are all very complex topics and things that I will address in a subsequent capsule in this series. So for now, I hope you've taken from this the way in which when you're talking about a concept that seems as simple as corroboration, you're actually sometimes referring to a lot of different things, and a really good idea to have those sorted out in your mind before proceeding any further. That's all I wanted to talk to you about in terms of corroboration. Hope that was of interest to you. Have a great day. To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.